o'clock. So we are here tonight to continue the March 24th, 2026 election. We have received back from the Maine Supreme Judicial Court the 2 ballots that were in question. And at this point, I'll turn it over to Stephen Wagner.
Good evening. My name is Stephen Wagner. I've been asked by the Select Board to help offer some guidance for tonight and some explanation of what we're doing tonight, which, as the clerk said, we are acting pursuant to an order of the Maine Supreme Judicial Court to resume counting of the 2 absentee ballots that were discovered uncounted after the March 24th, 2026 municipal election for the town of Clifton. So first, just a reminder that it is a Class D crime if anybody interferes by force, violence, or intimidation, or any physical act of the public official is performing an official function related to the municipal election. Just wanted to read that just so we can keep things orderly. So, order of proceedings tonight. Let me give you an outline. So I've been asked to read the advice that I provided to the Select Board, so I'm going to start the evening doing that. I'll then proceed with a summary of the process for challenging a ballot, the process for counting the absentee ballots. Then we'll proceed to count the absentee ballots. We have received one request for an inspection, so we will allow the inspection to occur before we proceed with the counting. Then if there's a challenge, again, I will read some instructions about the process for processing that challenge. We'll go through that challenge process. We'll then resume the counting, and then we will declare the result and discuss any of the next steps after that. So with that, you'll bear with me. I'm going to read through the 2-page letter that I sent to the Select Board upon receipt of the Supreme Judicial Court's decision. I'll paraphrase it a bit so it'll go a little bit faster. So I am writing concerning the Maine Supreme Judicial Court's decision issued yesterday in document number 26 and 842. As you will recall, the town of Clifton submitted a petition forwarding an affidavit from Gregory Newell challenging 2 absentee ballots cast in an election for a 1-year position on the town's Select Board. The original election was held on March 24, 2026, and counting of the election resumed on March 27, 2026, following the discovery that a clerical error led to 2 absentee ballots not being counted. When a challenge was made concerning the validity of the 2 absentee ballots, and it was determined the result of counting the 2 ballots may impact the results of the election for the Select Board position, the ballots were not counted, and the challenge materials and ballots were forwarded to the Supreme Judicial Court. As the election results originally announced on March 24, 2026 have not changed, the clerk confirmed the results of the election and swore Cynthia Grant to the 1-year position on the Select Board. In its decision, the Supreme Court dismissed the petition forwarding the challenge materials because it found the affidavit did not contain sufficient information that, if true, could invalidate a ballot, and therefore the court declined to invalidate the ballots, which must be counted. More relevantly, the court has asked that we count the ballots. So, to facilitate these next steps, my office has coordinated with the court, arranged for personal delivery of the election materials to the town of Clifton as soon as possible. Those have since been received. To comply with the court's order, I recommend setting a date and time to resume counting of the 2 ballots. Here are the specific steps. The clerk should contact Steve Armenia and Cynthia Grant, the candidates for the office that may be impacted, and try and find a date and time in the future to count the ballots that is mutually acceptable to the town and those candidates. And that was done. They're here. The election workers will then open and process the absentee ballots. There's not a specific timeline, but I recommend the arrangements be made as soon as possible, so long as the candidates and public have 24 hours notice. This should be a duly open meeting open to the public, and the candidates and the representatives should be permitted to observe, just like they would. This is a recount or an inspection. Through the usual means, providing notice, announce when and where the process would continue. That's been done. Okay, so I also wrote that this raises at least two questions, of which I offer my opinion. First question, can someone challenge the ballots again? In my opinion, yes. However, consistent with the court's order in Title 21A MRS 696, the challenged ballots must be counted. In the event the ballots are again challenged, and upon opening and counting them, it is determined the results of the election have changed, the envelope containing the challenge certificate and the signed affidavit under 21A MRS 673-1 must be forwarded again to the Supreme Judicial Court for resolution. And although it's not stated in the statute, I recommend submitting the challenge ballots themselves along with the absentee ballot materials. The second question this raises is, what if the counting of the two ballots changes the result of the select board position currently occupied by Cynthia Grant? My opinion is that if the counting of the two ballots changes the results and the ballots are not challenged, then I recommend Cynthia Grant be deemed to have vacated the position and Steve Armenia sworn in. If the counting of the two ballots changes the results and the ballots are challenged, then I recommend suspending certification of the results until the Maine Supreme Judicial Court determines the validity of ballots. Under these circumstances, Cynthia Grant would remain in her position until the court rules otherwise, essentially preserve the status quo while the court resolves the matter. I understand that we've since spoken with the clerk of the Maine Supreme Judicial Court and have been advised that the court, if this comes back before them, would issue a decision as soon as possible, recognizing the urgency. So, that was my letter to the select board. I'll proceed just to a brief summary again of the right to challenge the ballots. So any voter in a municipality may challenge the right of another to vote in that election under Title 21A. An absentee ballot may be challenged in the same manner as a regular ballot. Statute further provides that the challenge to an absentee ballot must be made after the voter's name has been read and before the ballot is placed into the ballot box and voting machine. Obviously here, we're not placing them into a ballot box because we already have the ballots and we're just opening them, so I would suggest the time for a challenge is when we initiate the process of reading the name and before we proceed to opening the envelopes. So, if a challenge is made during that time, I will instruct the clerk and moderator to pause the counting, and I will read the instructions on how we would proceed with a challenge. So, the process for counting the absentee ballots. So, this is essentially a modification of the normal process that you all will follow here. So, the moderator should review the notes on the envelope. So, do we want to start that process?
Are you going to do the inspection of the envelopes prior to them being opened?
Well, we have to open this ballot, and then, yes, that would be the appropriate time to allow the inspection. Are you the gentleman that submitted if you'd like to come up here now, that would be great. Yeah. So once we have opened the materials and confirmed, I would ask that you allow this gentleman to inspect.
Oh, who is he?
Could you identify yourself, sir?
Yeah, you want to?
Well, I'm going to, if I can, just represent that you are Jeffrey Niles, and we received a timely written request pursuant to Title 21A to allow the inspection of the absentee envelopes before processing.
The applications.
Yes, we have the application. No, I don't believe those were sent to the court. Those should be with the rest of the election materials. So they should be secured with the absentee ballot materials.
And the other one.
All these are treated those, and I just confirmed that we have the voter list with us.
I don't think so. Yes, I expect this is probably going to be 10 to 20 minutes. You can ask him. Oh, yeah. The amount of time that she's been talking to him already. I think good.
And you're getting applicants to
Yeah.
Yeah. That's good. Full house.
He's got to be Mark. I don't know if perfect, but I mean, we'll talk about it.
I assume we're not allowed to ask questions about the court's results. We just have your statement that you're listening.
It's not a public meeting. Certainly if the select board wants to entertain them, wants me to stick around to discuss that, I'm happy to, but
It's not worth the money.
Didn't you say it was a public meeting?
it's not a public meeting in the sense of a meeting of a body where the public has an opportunity to comment.
Whose decision is that?
Yes.
Who makes that decision?
It's state law. This is not a public. It's not a public hearing. This way the public would have a right to speak, or a meeting of the select board where under the recently revised law, the public would have a right to comment.
You ever gone through one of these before, like this?
Sorry.
Have you ever gone through what we're going through right now?
Is anybody in the state?
That's what I was wondering.
How long does it take to find neighbors? Everybody could just be patient. And, yeah, that's the best one.
We'll get over it.
Hi, Casey.
I should be able to register to vote right now. Start with the selection.
You guys want to get one?
Incoming,
Yeah.
I would still not.
Just give me that.
So where are the ballots?
No, do you want to?
Yep. No, those.
It is now, I see them a couple. First one.
Right.
I will admit, it's a lot of talking. All but I'm bad. Then what do you win? I didn't try. I heard the first time he said it was one year. He is a lawyer. I believe the statement is alleged. Leave with that. We had the last meeting, that's just grammar. Your partner in the garden all like that.
No, I should probably. Yeah, you can't. Well, I can't. I wish I had time. Sorry.
So thank you, everybody, for your patience. What's happening at the moment is the clerk and the two ballot clerks are searching through all of the election materials to locate the original absentee ballot application that, according to their recollection, was secured with these materials. They have not yet been able to locate. So they are thoroughly searching through all of the envelopes that are in that container.
To be careful, but at what point, for the good of the town, and given how convoluted this process is, could we call for a new election period?
I think at this point we're under an instruction to open the ballots. So what I would recommend we do here is give another, we'll just call it 5 minutes to search for the records. I'll then have everybody come back and we will inspect what there is to be inspected, make a note of the materials that are missing and are not able to be inspected, and then proceed with opening that practice.
The judge's order, even without the proper. Now we don't, if we don't have. Right? If there's no application for the roadway. So even if you have a nice even way to this person being and that person may not want everybody to know, because everybody knows these ballots are. Once we get the right information, we'll be opening up these ballots instead of getting this guy. Yeah, I know, they know the rest of Clifton Maine. This is one that I consistent.
I apologize. everybody, seriously. I will.
Could someone let,
And
can you let them know that they can stop searching?
I already.
Oh, you
they're
already?
here.
Okay. All right, so thank you for everyone's patience. The two absentee ballot applications were located where they were supposed to be. They just weren't noticed the first time that they were leafed through here on the table.
Yep. Did you show them the list? Oh, we both. No.
And the other, back to the other one.
Yep.
Anything else to inspect? Okay. So with that, we'll proceed with the counting of the absentee ballots. So, moderator, have you reviewed the notes of the clerk on the return envelopes? Okay.
Yep.
Moderator, have you found the affidavit and the aid and witness certification, if required, and properly completed?
Yes.
Okay, has the clerk verified that the signature on the envelope matches the signature on the application, or that the voter confirmed that the voter personally signed the return envelope?
Yeah.
Okay,
How?
at this point, we're,
Yep. That's, yep.
if you want to make a challenge,
Yep.
at any time you want to make a challenge.
Their names have to be announced before I can make a challenge.
Correct. Moderator should then examine the incoming voting list to determine whether the voter voted in person at the election.
Good.
Can you review the incoming voter list to determine if the voters on the absentee ballots voted in person at the election?
They did not vote in person.
Okay. Moderator, then please announce the name on each absentee voter who has not voted at the election. So please announce the names.
Patty Fulton and Michelle.
So now would be the time that there's a challenge.
I challenge the right of Patty and
Oh.
I think Melissa.
I'm okay proceeding with the two challenges at the same time.
Yeah.
If you are. So, sir, could you please enter the cones? Madam Clerk, do we have the affidavit forms? Okay.
Oh, sorry.
So I will leave it to you and the clerk to proceed.
Sure.
Unless there's any objections, I'd just like to read to the audience the process for the challenge that we're going forward on. So the challenge must be made to the moderator in the form of an affidavit signed as a vote. The affidavit will include the challenger's name and address, party affiliation, if any, status as a registered voter, name of the challenged voter, and the reason for the challenge, as well as the specific first-hand knowledge upon which the challenge is made, and a notice that the affidavit is made under penalty of perjury. Title 21A MRS 673A1 sets forth 12 grounds for a challenge, and there are copies here. It is, as the court found, the challenger's responsibility to fill out the affidavit, so I provided the of the statute, and we provided the form from the MMA manual with the addition of a notary attestation line. And I would just ask that we make sure that the moderator administers the oath to the challenger, that they solemnly swear that the statement in the document is true to the best of their knowledge and belief.
So I've prepared an affidavit. However, the reason for the challenge has changed since inspecting the ballots. Do you want me to write it on this affidavit? Or do you want me to
That's up to
make
you.
modifications to mine?
That's up to you as the challenger. I'll submit however many pieces of paper you want to constitute your affidavit. Yeah, please.
The first sentence you read is he's supposed to be doing this with the moderator, I believe. The first sentence you read.
That is correct. Could the moderator?
When are you going to submit this?
If we make a determination that the number of challenge ballots could affect the outcome of the election, the statute instructs us to submit immediately. So my recommendation to the select board would be that we would, in that case, submit it tomorrow. The moderator disappeared, so this is the oath I'm making to have the challenger make it. I'll have to record this all the last time. When it's ready. So while the challenge process is going, I was just speaking with the clerk to get a better understanding of what the delay was in finding the absentee ballot application materials. And so I understand through the normal course, those were stapled to the back of the voter list. And now what would normally happen is upon opening of the ballots, that application would be removed and adhered to each of the individual ballots and stored in, because we had a unusual process of those ballots not being open. The clerk didn't think to check the back of that first immediately. Instead went, as you normally would, to the absentee ballots, which is what everybody was searching through. So, apologize for that delay. Appreciate everybody's patience. Yeah, well, going to see. Once you're done moving, we'll discuss something. So one suggestion, I think along the lines of what you're suggesting before, is we could have you just fill that out and write C attached, and you'll staple it all together. That way the moderator could administer that vote. We all sign there. Or you have an attestation.
I have an attestation.
Whatever you would prefer as the challenger, just use it again, or we could use your form as an attachment to the
Let's do both of them,
Okay.
and we'll notarize this as well.
Yes.
Should be reported about the moderator, just
No, not when we're proceeding under the municipal election.
I hereby swear that I am a registered voter in the town of Clifton, and that the information presented above is true and correct to the best of my knowledge. I understand that any false statement made in this challenge affidavit is punishable under penalties of perjury.
Okay, and then both the moderator and challenger need to sign the challenge certificate. Yeah, the deputy clerk would notarize that for us.
Was this challenge made to the warden?
It's a moderator when they're operating a purely municipal election under Title 30A. So, yes, that is the moderator.
Let's be very clear. Who is the warden at this
Time.
election?
I actually hold two.
There was no warden.
I understand the answer is the clerk is operating as the clerk, and the warden, my opinion is that when we're in a municipal election, the moderator holds the position of filling out the challenge certificate.
So it would be your opinion that this was under oath administered by the warden?
No, it's an under oath administered by the moderator.
So
Do it twice.
in order to challenge a voter under subsection 673 or section 673 subsection 1, the challenge must be made to the warden.
Yeah, and when you're dealing with a municipal election, you operate under Title 30A and consult Title 21A as applicable to the municipal election. And under Title 30A, the moderator assumes this responsibility. That is what is laid out in Maine. Moderators are in the Municipal Association elections guide, but certainly if it's your request to have the warden also administer the oath and sign it, I see nothing wrong with the belt and suspenders approach.
That is very strong in my opinion. As the warden would sign it as well.
Yes.
Under this one, notarized as well.
I don't know where can you see that stack of stuff. So this challenge certificate also needs to be filled out.
The last page of that.
These are just empty extras.
Under the statute, does the challenge.
So it's Table 21A, Section 673, subsection 3. The warden shall write a number on the outside of the ballot. The warden shall also complete a certificate on which appears the word challenge, the name of the voter challenged, and the reason for challenge. The challenger and the warden shall sign the certificate.
I won't complete that, the warden needs to do that.
No, it says right here, the challenger and the warden shall sign.
Yeah, I'll sign it.
Oh, yeah, I
It
agree.
says
I agree.
the warden shall also complete a certificate on which appears the word challenged.
Yes, and you can see here, under the moderator's manual, which explains that under Title 30A, the moderator assumes this role.
Okay. That needs to be filled out.
Yeah, so the moderator, could you please fill that out? And when it is ready, the challenger will sign it.
You could put C attached affidavit, I think. C attached affidavits.
If they kick us back for that,
Oh, they were pretty pedantic last time. Maybe the voters changed.
just right at the top. No, right on the line. Yeah, there's some further instructions. Parking. Yeah. So that's why I'm gonna have you sit down. Unfortunately, we
No,
were deduction and everybody.
Yep, no, I'm very aware.
I'm asking you to read the document for today.
But unfortunately, we're past there.
The deputy clerk could then notarize this as well. Once that is done, I'll ask the challenger to return to his seat. ballot clerk in charge of the voting list should please mark challenged next to the name of the voters that have been challenged and give the ballots to the monitor. Okay. Then I would like the moderator to please assign a unique number to each, different number to each ballot. I know this has been done before, so what I would recommend is that you, write a new set of numbers that are different than those numbers. And why don't you just, cross those out and then just put a new number. Yep. Don't say out loud what numbers are, please. Okay. Right. Moderator shall put the same number next to the challenge on the certificate. So you can put two numbers on the challenge certificate. Okay. And please place the moderator, please place the challenge certificate and signed affidavit in a sealed envelope marked challenge certificate number and place the two numbers that you have assigned. Yeah. Okay, and so in that, please place the certificate and the affidavit. Close that up. Okay. So, we will now proceed to count the absentee ballots. So I'll read the instructions here. So we've announced the name. Remove each ballot from its envelope without destroying the envelope or unfolding the ballot. Election clerk from a political party different from that of the moderator, please mark the letters A, B beside the name of each absentee voter on the incoming voter lists and place a check mark or horizontal line in red ink on the list beside the voter's name. That's already been done. Process the counting as you would through your normal course.
Just read the name out loud.
Well, I would just, go through, add both of the ballots to the tally, and announce the revised tally.
I thought you said if there was a challenge that they weren't going to be counted.
That's not what I said.
I could have
The
sworn.
court, well, it's not. The court has ordered us to open the ballots.
Counting should continue after a ballot anyway, or after a challenge anyway. It should continue.
That's correct. I advised last time under the circumstances to not open the ballots.
Okay.
Do we have a revised tally
Yes,
for all races?
yes. What do you mean all races?
Well, I think we should revise all, go down, the whole ballot needs to be counted.
Just the.
Yeah. Yes.
Just these, right?
Yeah.
Okay. Lee Bryant, 141. Mr. Folsom, 73. Greg Newell, 111. Rebecca Vanu, 84. That was for a 3-year term. 1-year term is Steve Mania, 115. Cindy Grant, 114.
So as we, by virtue of that reading, we determined that the challenges may impact if valid, would impact the race. Therefore, I'm going to go back to reading the advice I provided previously. So, in the event the two ballots change the result of the select board position, and they are challenged, I recommend sending the suspending certification of the results until the Supreme Court determines the validity of the ballots. And so under the circumstances, we would preserve the status quo, the current office holder would remain, and we'd be assured that the court will review this matter as soon as possible. That is my recommendation. Ultimately, it's the moderator and the clerk who decide if we're going to suspend certification of the results and just immediately send these materials back to the court to resolve.
And as a town clerk, I agree with the town attorney that we'll suspend for now and send it off to the courts to make that decision.
Okay. I will look to the select board chair to instruct me as to exactly the materials to send to the court. The statute says merely the challenge certificate and the affidavit. It's my opinion, in the interest of efficiency, we send the ballots and the absentee envelopes and the applications.
I would agree with that. Would it hurt us to send, usually less is more, but in this case, full transparency, do we want to send the entire certified election results as well?
A copy of the election results?
Yep.
Yep.
I see no issue with it.
Okay. So that is what we would do. I would ask that all the materials be secured. Confirm what we have here. So we have the sealed challenge certificate, which contains the certificate and the affidavit. We have the two ballots. And the two envelopes. We have the two applications corresponding to the two envelopes. We have the tally sheet dated May 6th, 2026. We have the original tally sheet dated March 24th. The incoming voter list. Mr. Chair, did we determine we wanted to send the incoming voter list as well?
I would send everything that we think is even remotely relevant, so this doesn't come up again. That's fine.
I agree with you. I concede it's not following the statute by the letter, but I think it's appropriate under the circumstances.
This is the law. And they came in.
All right, so those are the materials. What is this?
That's what came back from court, what we sent originally.
Okay. So I'm going to put this on here. And And do we have means of sealing this up?
I can go get some.
Yeah, you can get some adhesive. And once you've sealed that, I recommend that it be placed in the container that's holding the remaining of the ballot materials. And then my office will arrange for pickup of that material along with a petition and submit that to the court.
Wouldn't packing tape be better?
Go to town on the tape. Go to town on the tape like I write on Christmas lists. It's just all over. There you go. So, while the clerk secures, moderator, you have the honor of closing the resumption of the counting of the March 2026.
What is it, 7:05?
7:00.
7:05.
Thank you, everyone, for your patience. Thank you, Madam Secretary.